Well, good morning, good evening, everyone. My name is Chiara Giorgetti.
Where's the guy who runs the camp?
It's on. I checked it.
Okay.
My name is Chiara
Not for me,
Giorgetti.
for them.
Yeah, well, of course, because it's wonderful that Judge Brower allows us to record this event that's going to be then available on the ASIL website. This event is organized by the Interest Group on International Courts and Tribunal, and it's that I co-chair with Group Study of the PCA, and it's really a wonderful privilege and an honor for us to welcome today Judge Brower. We could spend an entire hour talking about the achievement of Judge Brower, but he asked me to be very brief. I would just like to say that he is the former president of the American Society of International Law, as well as the recipient of the Hudson Medal, the highest honor that is given by the American Society of International Law. Of course, he's been an advocate to be in the Iran-US Claims Tribunal for many years. He's a former partner at ICTIG and also served in the Reagan administration. When I was looking over at ECB, apart from looking at the Iran-US Tribunal, he also was a judge ad hoc in the Inter-American Court of Human Rights, and he sat in the experts as a register of experts for the UNCC. So really an incredible wide of expertise. He's been defined as the easiest arbitrator, and one of the most sought-out arbitrators in the world, particularly on matters of investment arbitration. It's a wonderful privilege really to have him here. He's going to talk for about 20 minutes about the future of international arbitration is the past proverb, and he asked me also to say that he's going to welcome questions very much, and really hopes to have an exchange with you. Before I pass over to him, I'd like to point out an event that ASIL is organizing next week, and you have a brochure on your chair. It's January 24th, International Law in the Advanced Sector Administration, Priorities and Properties. Thank you very much, and thank you very much, Judge Brower, for coming to talk to us.
Thank you. Looking out of the audience and seeing so many people who have been part of my life at different stages and in different iterations, I feel like I'm attending an old TV show, This Is Your Life. Justice Breyer has spoken at some luncheons and other meetings that I've attended, and I believe he's spoken at the Society as well. And I've noticed over the years that he's moved from giving speeches to more or less simply getting up and say, well, why don't you just all ask me a lot of questions, which saves speech preparation time, but also is very informative. I make no pretense to an eminence approaching that of a Justice of the United States Supreme Court, so I will talk a little bit, but I really look upon this as an opportunity to answer questions of all types. And as I said often, there's no such thing as a dumb question. Don't be concerned about what the question is you ask. There might be a dumb answer, and that'll have to be sorted out by you all. Some years ago, there was a book published in the 1980s, the title of which was Dealing in Virtue, which some of you may know and some of you may even have read. It was published by an American lawyer who at the time was the head of the American Bar Association Foundation, which is a research institution, and a French sociologist. And it really was a socio-political study of the institution of international arbitration. I'm kind of wondering what the book would look like today, 25 years later or so, because the latest publication I have read came across my email first, published by a non-governmental organization in Europe entitled profiting from injustice. And the organization is self-declared to basically be, I would say, anti-corporate. And it lists, among other things, 15 allegedly elite arbitrators who are profiting from injustice suffered by the various parties to these investment disputes. Well, I'm number 2 on the list. They're listed by number of investment cases in which you've sat, in which you have allegedly dispensed injustice. Now, these are sort of bookends to the last 25 years. Dealing in virtue was an interesting approach, and it's a time that predated any activity of a serious nature with respect to bilateral investment treaties, NAFTA, the Energy Charter Treaty, and so forth. Now we are in the midst of a growing attack on the whole concept of international investment dispute arbitration, and such luminaries as the then Attorney General of Singapore, now a judge under Court of Appeals, in a speech at the meeting last June in Singapore, the International Council on Commercial Arbitration gave a speech pretty much along the same lines. Now, the basic nature of the institution has not changed, but the view taken of it by various constituencies is in flux, I would say. And while many people would be quick to pick on certain states in South America as being against the concept of international investment dispute arbitration, I have to say my own country, the United States, is a notorious offender in certain respects, as is now Australia. Of course, the United States was joined by Canada and Mexico in the infamous act at the beginning of this, early in this millennium, which decided to interpret, I will put that in quotes, the fair and equitable treatment and protection provision of NAFTA to be nothing more than what is provided by customary international law, which was seen to be embodied in what is known as the NER case from the 1920s and the United States-Mexican Claims Commission. And it did it after a NAFTA tribunal had decided that such an interpretation would, quote, be patently absurd, end quote, raising some considerations in the case as to what the effect of the, what was touted as an interpretation would have on the case. Australia recently has announced under its present government it will not negotiate any bilateral investment treaties. Jim Spiegelman, who's a very renowned, recently retired judge in Australia, said at an LCIA meeting when asked why is Australia doing this, he said, well, it's very simple. Not that he supported it, but he was explaining it. We're an importing country, not an exporting country. And for people who are coming into the country, our courts are fine. They're as good as American courts, London courts, so on and so forth. And if our people want to go abroad, well, they can always, you know, set up in the Netherlands and use their bilateral investment treaty with whoever or somebody else, so on and so forth. That depends upon the terms of the treaty, obviously. So there is a rather broad, I would say, NGO political attack on the institution, and it's sad to be that it gains traction with officials such as the then Attorney General of Singapore. If you follow what I saying and speaking the next few months on a couple of other occasions, you'll see more about this. But it is, I would hesitate to call it a crisis, but we're into difficult times. I think that we have essentially defeated the proposal of Jan Paulsen that there be no party-appointed arbitrators unless the arbitrators are appointed by both parties, and otherwise they should be appointed by institutions. But there still is a certain sentiment, and it's in more government or at least statist circles, to have, let's say, a body of people appointed or elected in some way, which would be the exclusive group from which arbitrators can be selected. And as I've often said, if you have any experience with elections to the International Court of Justice, or even the International Law Commission, or international organizations in general, you will know how big a role politics play, and how the role of who really is the best person for the job is, I should not say secondary perhaps, but it's heavily influenced by other consideration. And we all have known of, let's say, judges of the International Court of Justice, of whose work we were not exceedingly enamored, leaving aside what their decisions were, just the entire approach and the work ethic. So it's past prologue. Well, I have to go back and look at the definition of prologue. I think the machinery is being preserved. I don't think that Jan Thunberg's idea that there should be no such thing as dissenting opinions ever in arbitration lost about 70 to 30 in the recent conference in which the issue was put and people were polled. And pretty much the same reaction has been seen in such places as the White Case Annual Survey of International Arbitration, when companies, potential parties, are asked whether they would prefer to give up the right to appoint an arbitrator in a case and the right to collaborate in the appointment of a chairman of the tribunal. But the system in international investment dispute, as I say, is it's under attack. And as usual, it's like any coming back the other way. It's like guerrilla warfare. The attackers, of course, they're motivated, they're armed, they're vocal, and it's the people who are defending who need to be motivated to defend. So I encourage those of you who might be so inclined to be involved in the defense of the system. It's curious, as Antonio Parra will know perhaps better than any of us, that ICTIG was established in the 1960s for the precise purpose of depoliticizing investment disputes between foreign investors and host countries. That worked much better when the disputes were based on contracts. But as soon as it came to be issues of you, country X, have violated international law and breached your treaty obligations, and larger sums became involved, it becomes very political, and there's just no way around it. So we're dealing in a political environment. I can't tell you what the future will be. It's always, if you believe in evolution, as I think I do, and not any of the other theories, it will change, but I think the essential elements are so far being successfully retained. Now, the title this evening is a little bit misleading because I promised also the organizers I would say something about how do you become an arbitrator, especially for younger people here who feel they would like to become an international arbitrator. And then a little bit about the United States claims tribunal, of which most of you, I take it, have heard in one way or the other. How to become an arbitrator? If I were to put up a website and it had FAQ, frequently asked questions, probably that would be at the top of the list. In a sense, it's most frequently asked by people who come to me or sent to me, referred to me, say, yeah, well, so-and-so is retiring as general counsel of company A, 55, and never been involved in international arbitration, but thinks this would be a nice retirement. So how do I get into it? Well, it's not appropriate to say in those circumstances what J.P. Morgan allegedly said to a passerby who looked at his yacht and asked how much it cost. J.P. Morgan's response was, if you have to ask, you can't afford it. So in a sense, at certain points, if you have to ask, well, yeah, right. But I've always been trying to be as helpful as I can to such persons, and there's always a way to get started, and don't lay it all out. And it depends very much on the individual circumstances. But if you're interested, well, there's a way to get started. Now, for the younger people, in particular, my answer to the question, how do people become arbitrators, I said is simple in the answer, but the implementation is something else. They become international arbitrators for one of two reasons. Either they have been intensively involved in the practice of international arbitration over a significant period of time, and through their work, probably their writings, their appearances, their speeches, their growing reputation, have first been tested. Somebody appointed them, and then people decided, oh, I do pretty well, and so they get appointed more because they have the experience. Yeah, they're proven in the field. Now, Jan Paulsen, who of course is one of the leaders of our profession, is a classic example, because that's what he's done since he graduated from Yale Law School way back when he went to work for Coulier in Paris. The other route is a bit more complicated. It's basically, I say, perceived stature. What does that mean? Well, it means parties look at some people and say, you know, I think that person should have the makings of a really good arbitrator. Now, an example of that would be my frequent colleague Yves Fortier of Canada. Now, he practiced law all his life with Ogilvy Bonneau up to a certain point. He did some arbitration. I wouldn't have known that he had any, global reputation in the field as he does now. But he had the good fortune to be law partners with a guy named Mulroney, who was elected Prime Minister of Canada, and promptly appointed Yves as permanent representative of Canada to the United Nations. Now, Yves had to be a very good lawyer, and he had also been known all over Canada at the bar. He had been president of the Canadian Bar Association. But when he left the UN, he made a decision to, I would like to sit as arbitrator. And as I learned later, he went around introducing himself to various law firms, and including a guy named Alan Redford, and Redford and Hunter were practicing as partners of the Freshfields, and they had this shuttle case coming along, raping arbitration over the underwater transportation route between France and England. And of course, being bilingual, he's a native French speaker in Canada, but a perfect English speaker who spent time at Oxford as a Rhodes Scholar, among other things. So he didn't have a lot of trouble getting started. One of his countrymen, Mark Lalonde, of course, had been 4 times cabinet minister of Pierre Trudeau, who was chief of staff, he was at first. And when Laurie Craig of Couillard went to see Trudeau to ask him to accept appointment as arbitrator in what was known as the Gurdish case, a big arbitration between the French provider of nuclear power facilities to Iran at the time, Trudeau referred him to Marc Lalonde, and that was his first case. Well, you don't have to be quite that famous, I think, but it's a combination of somebody thinks by virtue of whatever you have done, whether it's being a college president, like J. Michael Young, who spent some time in the State Department, he was the legal advisor, I think, as deputy legal advisor, and then went upstairs in some undersecretary or deputy undersecretary position. He was dean of the law school here at George Washington, president of the University of Utah, and now he's president of the University of Washington. He's been appointed in arbitrations. But there are others, as I say, it doesn't take necessarily cabinet level experience, but some combination of factors that make people think you're good. So the better, the surer or the less unsure route, obviously, would be to advance through a career in practice. And I do understand getting those jobs these days are not easy, and there's a lot of competition for them. And George Berman, as an example, at Columbia, has raised the question as to whether law schools are devoting too much time and resources to educating people for jobs that they will not be able to get. So that's how to become an international arbitrator. How did I become an international arbitrator? You might ask. Well, that's a good question. I never saw an arbitration until I was 45 years old. I had a whole career already established as a commercial litigator for White and Case in New York, where I first became a partner. Fortunately, in many respects, I resigned 4 months later to join the State Department in 1969. And I think it was a combination of the actual litigating experience and the international law experience, plus just, lucky connections in the legal law firm field that put me together in the one case with Sir Edward Singleton, who was president of the Law Society of England and Wales, and me, and I saw his help in a case which we thought would go to arbitration. It didn't, because we realized the client didn't have a leg to stand on. And then he called me up one day, and because he was dealing with a case which New York law was the governing law, he asked me if I'd like to help out. So that was sort of how it got started. One thing leads to another. But I'm confident that it would not have developed anything like the way it has developed had I not spent more than 4 years as a judge in the United States Claims Tribunal in The Hague in the 1980s, which in a sense was a political appointment. Without the political background I had, I'm sure that I would not have been appointed. And it wasn't so much because of my politics at the time, but just from my service in Washington. I knew all the people who in the Reagan administration basically got a job and decided who should go to the Hague at the time that I went, and that helped a great deal. Now, to the United States Claims Tribunal for a couple of minutes. there anybody here who doesn't know anything about the Iran United States claims tribunal? I suppose you wouldn't want to reach you. If that were the case, but I wouldn't take it personally. 32 years. 32 years. January 19 is when it was established. And many of you are too young to have ever seen this, but as Ronald Reagan was being sworn into his first term as president on the Capitol steps, television was going back and forth between that and the 52 American hostages who had been held in Iran for 440 days were getting off the plane in Frankfurt, as I recall, having been flown there from Iran. And that was the beginning of the Iran United States Claims Tribunal. Well, I can tell you stories from here until the annual meeting 2014 of the Iran United States Claims Tribunal. John Crook can tell you more, having been the agent there. Tom Johnson, my new American colleague on the tribunal triad cases there back in the 80s. Now he's a judge of the tribunal, and there are others who've been involved. Is it a model for anything? No, not unless our country and a foreign country have basically gone through a crisis which wound up as what is known colloquially as a Mexican standoff. What happened in Iran happened in Iran. They had various reasons to want to resolve the problem, but you couldn't say they won. You couldn't say we won, other than getting our hostages back. But they, of course, regained control of $12 billion of assets, which had been frozen by President Carter. A number of those were pre-designated to pay off loans and so forth, so there were a number of bells and whistles. They didn't have total control of those assets, but of a lot of them. So the result was a tribunal like I think there has never otherwise existed. I'm always happy to be corrected. But here, because of the nature of the resolution of the dispute, you've got 3 Iranian judges, 3 American judges, 3 from third countries. It's supported financially by both governments, 50-50. Each has an agent before the tribunal, all have law clerks, and so forth. But everything's decided by majority. All of the post-war claims commissions and Mexican commissions basically arose out of situations where we had won or predominated. And so you could set it up much differently. It could be much more efficient, and you wouldn't have the kind of problems that we have had sometimes at the tribunal. Now, one interesting, fairly recent development is the issuance, actually, of a decision by the tribunal over the signatures of all 9 judges in unanimity with no separate opinions of any kind. And that was a decision rejecting the request of Iran for a, quote, revision, end quote, which means reversal of an award the tribunal had issued after 16 weeks of hearings spread over 18 months and about 2 years of off and on deliberations interrupted by challenges through third country members of the tribunal, so on and so forth, which award had resulted with 0 for Iran as the claimant by a 5-4 decision. So that was quite a moment. As soon as that decision, as soon as the award, which was impugned, was issued, our 3 Iranian colleagues disappeared. They had resigned a year before, but stayed on to finish the case. They were replaced by 3 others who were much more sophisticated in general. 2 of them with PhDs from English universities. One a Supreme Court justice of the past in Iran. One other busy Iranian arbitration counsel and arbitrator. And the third, a teacher. I think they got the idea that there wasn't much point in sort of ranting and raving about what was done, and they were convinced to join in a unanimous decision against Iran. Now, whether war will follow, that remains to be seen, but that's where we are at the moment. And now I've consumed 20 minutes for sure, if not more, and so I will stop and hope to be asked challenging questions.
Well, thank you very much. Thank you very much, Judge Roberts. It's been a very interesting speech, and you really gave us a lot of very interesting issues to think about. So I would really like to immediately open the floor to questions, because I know there are many issues that Judge Robert touched upon, and we can follow up.
No.
I don't know what the opposite of the peanut gallery is, but this is it.
Thank you, Judge. John Crook. We're all familiar with the criticisms that are being levied at direct investment arbitration and the sort of academic writing and so forth. But it seems to me the real test is ultimately whether governments are prepared to give and maintain their consent. And there it seems to me that the pattern seems to be more on the pro than on the con side. China is out there furiously concluding treaties. There's apparently a Chinese-Canadian treaty. There are no treaties out there. But I'm struck that in the discussion of whether this is all a good thing or not, there are 2 issues that seem to be very important that don't figure in the discussion at all. One is the point that one of the reasons for doing these things, at least inside of some large governments, was to get these issues off the political agenda, to make it just that, to remove them as bilateral irritants. And it seems to me that remains a significant value. The other is one where there may be some serious economic work, but I've sure never seen it. It seems to me ultimately this is all about risk allocation. And BITs are really devices for managing risk. If you're an investor looking in from outside, if you have the protection of the BIT, your risk is going to be slightly less. If you don't have a BIT, you may still invest, and it's going to cost the recipient more. And I'm not an economist, but I'm just not aware of any sort of serious work that examines that dimension of the problem. I'd be curious if you or anyone is aware of that kind of work.
To be honest, as to the latter point, I'm not aware of that work. There is some literature now on the subject of how well or how badly the respondent states are faring. And actually, particularly in an article done by our statistician in the field, Susan Frank, shows that states do very well. Actually, they don't lose 100%. They don't lose. The Iranian United States Claims Tribunal, the Iranians, of course, were always complaining they're always losing. We'd say the purpose of this tribunal is to adjudicate legitimate claims against Iran. There were practically no claims by Iranian nationals against the United States. They're supposed to lose. That's what this is for. Not so with investment dispute arbitration. And when you look at the dismissals for lack of jurisdiction or dismissals on the merits, and beyond that, you look at what's actually recovered in case of how many claims are honored and what's recovered on them. States are getting a very, very fair chance if you're looking at 50-50 or something like that. I think it is generally understood what you said, that it's, they're going to pay more because investor has to buy insurance, or it has to up the price, or both. If there's no the treaty doesn't cut something off. But I haven't seen myself studies on that. Your first point was
Political agenda.
Oh yeah. Well, you know, actually, I'm not sure how realistic the hopes were that generated the ICTIG convention, because, as some of you know, I represent the Republic of Indonesia in the EPCO Asian case, which we managed to drag out for, I represent Indonesia, drag out for 11 years, went through one arbitration, an annulment proceeding, second arbitration, second annulment proceeding resulting in the annulment of a supplemental award. And I'm sure, I've never done the calculation, but the legal fees, I'm sure, were vastly exceeded the $2.some billion that Indonesia is required to pay after 11 years. That was a political case. That's not generally understood, but if you know Indonesia at the time under Suharto, the army was a major factor. And this was really taken as kind of impugning the honor of the army, because it was alleged that army and police had basically taken over, unlawfully taken over this hotel known as the Kartika Plaza. So I'm sure the finance minister was called upon to defend the honor of the republic. It wasn't political, it wasn't globally political in the way it was broadly publicly political, as are many of the cases that are coming through now. And that was a contract case. So I think some of the early cases were quite small, involving West African countries, I recall. But when there's more at stake, it becomes more political. And I don't think there's any way around it. Judge Johnson.
Tom Johnson, now of The Hague, formerly of Washington. I'm going to pursue the point that John was making. So push you to go a little further on this, Judge Brower. Because I think John was right that a principal purpose of these treaties, if not the principal purpose, was not so much to avoid political element of disputes, because you're quite right, a lot of these disputes were certainly in the case of the respondent state. There's a big political issue domestically that is driving what they do. But it is the case, isn't it, that they've taken these disputes very largely off the bilateral diplomatic agendas of the states involved. I mean, back in the 70s, you were both in the State Department, we were sending people down to Peru. It seemed every other month to negotiate with the Peruvians to try to settle a series of investment disputes down there. And that sort of stuff just doesn't happen between treaty countries. Anymore, somebody who not too long ago was lobbying the State Department to do something, on behalf of an investor, the first response from the beginning was, well, file an investment arbitration, to which the response was, there's no treaty. Oh, well, gee, that sort of was a mistake on our part. We do not have a treaty, because then we can let it go away. If that is continuing, and then to answer the one question, I have seen some studies that indicate that treaties, you can't show that treaties encourage investment. I don't know how good that stuff is, but it's not that it discourages, but you can't show that it's encouraging investment. So having said that, let me go to the final, the real question. Is Australia onto something? And that is, if you trust our courts, we don't need a treaty. You're going to invest here. The risk allocation has been done. You're going to look at that fine, but you trust our courts. And as for our guys who are going to invest someplace else, well, they will structure it. As the guy said, they will structure it to go through some treaty country. And that should be fine with the host state, because they want to see that risk allocated so that they don't have to pay any more of the investment than necessary. I guess I can say, is Australia not just at the front of the trend, but maybe a benign trend, maybe a good trend, as rule of law becomes more common and more real in more and more states.
Okay. Well, I'm reminded, you don't think this is on the point, but it'll take a moment. When I was a Fulbright student years ago, I was required to write a paper, so I wrote it on the proposal that George Kennan made in the BBC's Reef lectures in the 1950s, saying that NATO is a mistake. The way to deal with the Russians is to basically follow the Swiss model and have everybody armed and ready to answer the call, and we don't need all these troops stationed there and so on and so forth. And it was widely decried. He was a magnificent person in many ways, but he had some terribly wrong ideas, in my view, that being one of them. Of course, the answer to it is, it's okay for Switzerland. It's small, 6 million people, whatever. They got all these mountains, and they live there. But, we can't do that for the plains of Western Europe. And this is the same. What might work for Australia, you can't do that as one of the two mega powers now. A country like the United States simply cannot afford to do that. Furthermore, it will have consequences because, as you know, a number of bilateral investment treaties require that the national of the investing national of a state must actually have a material presence in that state. Well, it's easy to start negotiating treaties that way or seek amendments and so forth. I think it's, in the long run, it's kind of a bummer, and it only exacerbates one of the points that's made against investment dispute arbitration, that there's treaty shopping going on. It's kind of a shell game. What you see isn't real. It's just, some guy, wherever it is, using, I've had this argument made in a case involving the use of the Treaty of Cyprus. It's just a letterbox company, in the English expression. Well, that's what the treaty provided, but it can easily be changed to provide that you have to have a real presence there, which is running too frequently. And it's a denial of benefits. It's a type of denial of benefits clause. So, and will it last in Australia? Let's see what happens in the next election. There's a certain content to it. You're awfully silent in the back there. I'm sure you're sitting on something we should know about.
Another question for you, Judge. You mentioned dealing in virtue at the time. The authors spoke of the grand old man of arbitration, and the field has grown enormously. But one of the criticisms is that there is still this group of largely men, I guess 2 or 3 women, who are involved in investment arbitration. But there's a perception that there's an increase of conflicts, that many of these arbitrators also represent claimants, in particular in some of these cases, and that somehow calls into question their ability to decide these cases fairly, because it's perceived that they have an interest, perhaps, in perpetuating this system. Do you want to comment, give you comments on this lack of growth in the numbers of arbitrators, at least commensurate with the growth in the number of cases, and any explanations for why there are relatively few people who have been able to break into the field?
This is a question that really should be answered by someone other than me, because of what I will be saying. This is a field that involves advancement purely on the basis of merit. It is the purest, or one of the purest meritocracies I know of, because as I often say, people in my position are up for election somewhere in the world, every minute of every day of the year. Somewhere around the world, somebody's considering potential arbitrators, and you only advance if you're seen as upright, fair, reasonably intelligent, I suppose, and experienced. What happens is, let's say you're the general counsel of company X, and you've got a bet-the-farm investment dispute. So you know you're going to have to answer to the CEO and ultimately to the board of directors. And what if things go wrong? Why do people go out and hire, in some cases, the firms they do? Because they want to be sure that if this thing goes south, nobody can say, why did you pick that firm, for God's sake? You know, there were 6 firms with this great reputation. And I know enough to know that firms that are not, let's say, the Freshfield White case or whatever, run up against this all the time because the company wants an insurance policy, or it can't be blamed. And it's the same with respect to selection of the party-appointed arbitrator. And there's somewhat of a dispute as to whether you should submit to interviews or not. I do submit to interviews. And I used to conduct interviews. I used to insist that my clients consider interviewing the person so that they're sure. I had clients say, I had one client insist that we meet the person. That was fine with me, but we had the general counsel, the assistant general counsel, me, and co-counsel from another firm that I was working with all fly over to Geneva to spend one evening having dinner with this individual. They have to be sure. So the other thing is, we're going to start out appointing someone to give them a chance, or it's uncertain. I know lots of people who I know are excellent arbitrators in the case if they sit in, or would be excellent arbitrators, but for one reason or another, they don't have the demonstrated experience in depth in the field. Also, so that's why people get reappointed in cases. It's insurance, but on the basis of hopefully demonstrated merit. Now, another thing that happens if you're, I've been suffering around the United States Plaintiffs' Tribunal. Of course, I'm doing nothing but sitting in such cases for the last 12 years. So I've sat with a lot of people. And when you sit with people through the hearings and then deliberations of a case, you learn a lot more about those individuals than you ever would have known otherwise. And I develop favorites for people, these are people I recommend them to anybody in any case, anytime, in any capacity, that are just really the goods. So when you are mostly appointed by parties, appointed by the ICC to chair cases from time to time. I've been president of one case, but of course I'm often in the process of trying to work with a co-arbitrator to appoint someone to lead a tribunal, and of course we're consulting with our appointing parties. So I obviously will always tend to favor someone that I know is absolutely solid, won't be swayed one way or the other by anything other than the facts as he or she sees them and the law. So it's not, I really want to dispose of the myth that it's a a closed mafia trying to keep outsiders out. I'm happy for more people to come in, and there are more people coming in all the time. You see fairly new names as cases progress. But the thing I most hate to hear is, oh yeah, well you do this and that because you want to keep getting reappointed, get more fees, and so on and so forth. And most of the people, at least at a certain age in the field, it's nice to have the fees, but the most important thing is that somebody wants them to do something, and they have a very challenging intellectual activity. Now that doesn't explain why there are not more women in the field, but as you can see, it's coming along.
I wonder if I can follow up and add something maybe a bit provocative. There's a recently this empirical new data coming out about arbitrators. There's a new article by Michael Weigel in England. The title is "Are Arbitrators Political?" And there's some data now that shows that somehow an arbitrator who's more often appointed by claimants often judges in favor of claimants' favorable issues, and in the same way, an arbitrator that is most often appointed by, responded by the state, then in the award is most often sides with issues that are of concern or relevance to the state. On one side, you can say, well, this shows that investment arbitration is problematic because you can show that arbitrators, you can predict how arbitrators will decide. On the other side, you can actually just show that the party appointment works, because if you do your homework and you look at the arbitrators that you want, the claimant actually is able to select an arbitrator that is sympathetic to his view, and that the respondent will do the same. I wonder if you can comment on this. What is your
I'd be happy to. Thank you. No, one of my favorite responses is, I'm not pro-investor, I'm not pro-state, I'm pro-investment. And that's what we should be about. I know Steve Schwabel has made the same remark when he's been accused of being a pro-investor. Now, there is no doubt, and names will not be named, that there are some people out there who are unreconstructed supporters of the states, and probably some who are unreconstructed supporters of investors. I'm not sure that I know of any of the latter. But let me tell you this, the market has a way of slotting you, rightly or wrongly. Now, who did I start being appointed by? You get appointed by your friends, by people who know you from the professional work you've done together, or the professional society work you've been involved in together, that develop an impression when they're out sort of on the market as an arbitrator. It's basically your friends who appoint you. And it seems that when I started out, most of my friends were representing investors. You couldn't find law firms in this country doing much for the states, frankly. Now that's changed. There's quite a group of lawyers in Washington and elsewhere who principally represent states, and there are a number who represent both. Well, I got appointed by a lot of investors at the recommendation of their counsel, and kind of, one thing leads to another, and they tell their friends. So in these Argentinian cases, first I get interviewed by Siemens, and they appoint me a case against Argentina, and then they tell their friends, and Hochtief, which is the biggest construction company, comes around, and Daimler, Chrysler, Mercedes-Benz, you know. So years ago, when I first met Derek Ballot, QC, and held the chair at Cambridge in international law. He was then president of Queen's College. This was way back, and I was considering him for appointment, although I had never met him, because of a peculiar circumstance. I wanted to offer a party the choice between the chairholder of Cambridge and the chairholder of Oxford, and I'd never met either one of them. So I met him, but I started twitting him about all the work he was doing for Libya and Iran and so on and so forth. And he said, very simply said, well, your case represents the United States, but I'm not Penast. And in addition to which, it's sort of the British bar's taxi rank principle, as they refer to it. You're obliged as a barrister to take the case that comes to you if you have the time, and you are qualified, and there's not a conflict. You're not permitted to turn them away. So I'm sure that I'm keen for leave others to judge rightly or wrongly. I would say wrongly, but in any event, it's interesting. You will see, you'll see in your OGBID or these various email things that come out that I've joined the unanimous issue of the word in a case just came out yesterday, I think, against the investor. It's not the first time it's happened. So that's all I can say on this subject. Oh, way in the back. You can't ignore the back.
Maybe here from Judge Brower, this may be a bit of the same sort of theme, but you've had the benefit of sitting both on ad hoc investment tribunals and on a standing tribunal such as Iran US. And I wonder if you have any particular observations about the strength or weakness of standing versus ad hoc. And in particular, we've heard discussion about whether there should be standing tribunals in investment, and whether you have any thoughts, having sat on tribunals from both models, on what might be appropriate or helpful.
Well, it's not so much standing tribunal implies, brings up the question of how are the members of that standing tribunal selected. Now remember, the Iran United States Claims Tribunal technically is a temporary thing. We've been through 32 years of it, and it's going to go on for a while. But it's a tribunal in which the two contending parties have appointed judges and played a role in the appointment of the third country judges. So that's very different. And if you would have a standing international investment tribunal to hear all investment disputes, I hate to see what the politics would be involved and say, we want someone who's more for the investor. Well, you know, we want someone who's you know, understands states, and there's a lot of politics involved, regional politics, and you don't wind up with what I think you do have in the present system. As I say, it's as high meritocracy as possible, and you're up for election every day. People make their choices, and therefore you don't get involved in all this political business. And every time I read the critic of NAFTA and other places saying, oh, these unappointed lawyers that we never heard of, you know, and these are public issues involving the environment and health and so on and so forth. Well, we signed a treaty delegating to us through an agreed appointment process. I act as an international arbitrator in a treaty case. I feel I'm acting as a public official in that sense, and I hope I carry out that responsibility. I hope that answers your, is a response to your question.
Hi, good evening.
Yes.
There are, of course, and you've heard of some of them, a number of proposals for reform or change, depending on how you receive the proposal, I guess. And you've mentioned some you dislike. I wonder if there are any out there that you think would be a good idea. Or if not a specific proposal, what do you think is something that could be done to improve the system?
I think I spend all my time supporting the status quo.
That's why I asked the
You
question.
will understand that. And that's not the case. You know, this is a field in which, to be blunt about it, a lot of people, a lot of organizations, many of which are in competition with each other, in some respect want to show themselves as being modern, you know, advancing, sort of making new proposals, and a way to get your name out there is to sort of make a proposal that people will discuss. Whether it's good, bad, or indifferent will eventually be decided, but in the meantime, one has gotten the press, as it were. I gave a keynote talk last April at the Forum annual Dog and Pony Show on International Arbitration. Arthur Robine, first agent at the United States Claims Tribunal, puts on, it'll all come out in a book next June, and the title of my speech will confirm your concerns, I suppose. It was simply, is there anything really wrong about international arbitration as we know it? And what I basically say in this regard is, you know, the basic elements should not be changed. We should have party appointments and party involvement, or opportunity for involvement in the appointment of the chairman. And the general desire of the consuming public for that has been well demonstrated in various surveys. Of course, there are things that can be handled on the fringes. I mean, one would be to, in some cases, have better qualified counsel presenting the cases, people who really know how to cross-examine a witness and get to the core of it. In terms of institutional improvements, I have not joined the school that says, as Tom Bergenthal and Philippe Sands have said, and I think Brigitte Stern takes the same view, that you should not act as counsel in such cases and also as arbitrator, even if there's no demonstrable immediate conflict. I don't happen to have the problem is I don't act as counsel anymore. But there's definitely an issue, the potential for conflicts. I think that could be better sorted out in some way. The procedures have changed quite a lot, actually. And the complaint is, oh my gosh, arbitration used to be so simple, and now it's like American-style litigation, partly because all the American lawyers are involved. And my answer to that always is, look, these are big cases. If people are in international arbitration because it's the only acceptable alternative to being in national courts on one side or the other, then why shouldn't you expect it to be something like litigation? So we have huge numbers of document requests, occasional requests for deposition. You never would have seen this 10 years ago. You have varying ways of dealing with expert witnesses. Some believe in witness conferencing. I'm I'm not for it or against it. It depends very much on the circumstances. I think there are improvements that are made. I think they come somewhat naturally. But if I were to sort of come up with a new proposal today, one of them would be to get the Chartered Institute of Arbitrators Practice Guideline number 16, which says if you're going to interview an arbitrator, it should be only in his or her office and only for 30 minutes, and there should be a memorandum of it and if possible a tape of it and circulated to all the parties, so on and so forth. That is insane. And I do submit to interviews, and as I may have said earlier as counsel, I always recommend it in interviews, and certainly have no objections to it, because if you're going to have a lot of money at stake and potentially principles at stake for the party, there's no reason at all for people not to spend an hour or two having lunch together and talking about everything but the case, just to get to know each other, get a feel for the individual, get a sense of the chemistry, whether you think this is somehow instinctively then someone you want to be involved in the case. So that's not a very precise answer to your question. So no, I'm not a. Short answer is I'm not status quo stuck in the mud, but there are an awful lot of ideas that are put out there by people for the sake of putting out an idea. You had something you wanted to follow. I thought you wanted to follow that.
Well, I could. It would be true, but I don't want to take it for something else. One response is to put it back to the states that include the treaties. And in some cases, this is being done. A lot of states are reforming, they're amending their treaties and making them more specific and including more exceptions. Do you think that that's a good way to go? And that's, because people complain the standards are too vague, they're inequitable. What does that mean? It can mean anything an arbitrator wants it to mean. So there seems to be a trend among at least some states to include more specific provisions or to carve out more exceptions. And what do you think of that as a way of reform or as a way?
That's their privilege. They make the rules. As to whether that will promote investment or not is I'm not really here to say. And the United States, of course, is as I mentioned before, one of the notorious actors in the field. But I mean, every arbitrator will tell you, look, if it's made absolutely clear there's no room for interpretation, well, that's what you do. It's interesting. I just finished the forward to a book which should be coming out soon, I hope, which is the doctoral dissertation of Todd Weiler, whom a number of you I'm sure know or know of, which I think will be very interesting. Certainly, I think the forward I wrote is very interesting. But I think it's interesting because the book is interesting because it's basically a myth-busting, or it advertises itself as a myth-busting book and goes back as far as the Bronze Ages to trace the development of the principles of full protection security, fair and equitable treatment, even compensation standard for expropriation, and basically says that customary these are, well, anyway, read the book. There is, yes, you can say, oh, well, gosh, it's subject to interpretation, so you can do anything you want, but you shouldn't do anything you want. And if you go really into the history, do a historiographical study of these terms, which this book does, well, you may be very surprised by by the results. I don't think I think part of the problem is, and as this book says, too many arbitrators have proceeded either in ignorance or with misinformation from somewhere, and he lays the blame largely on counsel for not having elucidated for the arbitrators the historiographical trail of these principles. Yes, I know. How are you?
I'm good. I just wanted to follow up on something you mentioned times now, which is performance of counsel and how that contributes to the quality of the process and to the understanding by the arbitrators of what counsel really wants.
Since I don't sit in cases in which a white case appears as counsel, none of what I said about counsel in my white case.
It's all more informative for us, of course, because we understand.
I'm sorry.
So the question was, what are the main points, the main areas for improvement in terms of counsel performance?
Oh.
You mentioned cross-examination.
Yeah, well, that's
overly documenting cases. So what are you doing against dirty boxes of documents? Right. These kind of things. Thank you.
oh well. Gosh, I could cite a long list. I was at dinner Monday evening, and it was all international arbitration types, and a woman partner in one of the well-known firms was at the table, and I really know her well at all. And I said, one of the issues that comes up is, look, before I went into international arbitration, I had tried cases. I had tried cases before juries. I'd examined witnesses, of course, in sit-ins and depositions, but also cooperative witnesses and hostile witnesses in court and criminal proceedings as well as civil proceedings. And a number of the people who have come into international arbitration during a certain period of time came from that background, and they know how to examine a witness. They really know how to present a case. And she said, I agree with you entirely. She said, I did that for 10 years before I got into international arbitration. I think one of the issues is that a lot of people come right into international arbitration. Basically, that's all they've ever done, and I don't think they've had the experience that others have had of examining witnesses. I gave something called the golf lecture out in Hong Kong a few years ago, and I was warned in advance that these people, it's sponsored by the Hong Kong International Arbitration Center and Freshfields, and I was warned in advance to have given the speech before me had talked a lot about investment dispute arbitrations, and everybody sort of nodded off because Hong Kong lawyers are not doing investment dispute arbitrations, they're commercial arbitration type. So the thrust of my speech in part was it's much easier for a trained commercial lawyer to learn the things he or she needs to know to deal with an investment dispute than it is for someone who's just been doing international investment dispute arbitrations to be able to learn the things that a well-experienced trial lawyer hopefully will have known. Other beefs are, I don't really want to see any more 200 to 300 page post-hearing memorials or submissions, and believe it or not, I've had them from well-known firms leading in the field. Just don't put up all the arguments under the sun, because eventually we'll cut to the core of it, and you might as well admit what the core of it. I was at the dinner by this interesting partner in Cravath, who's South African originally, is now getting into into arbitration. Right, now I lost the thread, sorry. Maybe it'll come back over time. Yes, I see a hand.
Judge Brower, nice to have you here today. I'm a George Washington University student, law student. I have two questions. On the same train of thought of how to improve the system, what are your thoughts on the default in honoring the compensation awards by Argentina and the recent declaration by other countries of the region, such as Ecuador, to follow the Argentinian example and not follow their commitments under the awards and compensation? And the second question, kind of related with the first one, is what are your thoughts in the recent trend of some states countersuing investors based on environmental issues in local courts, which in many cases, such as the Chevron case in Ecuador, have exceeded any expropriation compensation?
If I've understood the questions, I'll take the second one first. Having been appointed by Chevron in the first Chevron versus Ecuador case, which is the subject of current proceedings, I understand. I think it would be unwise of me to make any comment that might be construed as relating to it. I think your first question has to do with the failure of Argentina so far to pay any of the awards against it in these ICTIG cases and there are other cases, I'm all of those cases. Was that your question? What do I think of that?
Yes, all other countries are trying
right.
doing this.
Well, this gets into a somewhat political question. All I would say on the subject is that there is an express obligation, I believe, in all arbitrations that the award is final and binding, unless, of course, annulled somewhere, and is to be paid. And if it's not paid, then the person not paying is probably not playing according to the rules that were established, and beyond that, it's up to others to decide what all of that means. Certainly, in the ICTIG cases, there is an obligation on states parties to the convention to enforce in their courts the awards of ICTIG as the same as if they were judgments of the highest court of that jurisdiction. And that suggests that it's anticipated that awards would be paid. But I would have nothing to say on it further, as you may or may not know. I'm still sitting in cases involving one or another of the countries that you mentioned. Yes, Jonathan Hamilton, how are you?
How are you?
Okay.
Judge Brower, I have a question about the balance between efficiency and due process. One of the common complaints about investment arbitration is it takes too long. But as a practical matter, it's not always easy to change that. In one case a few years ago, the parties went to the tribunal at the end of the hearing and we proposed post-hearing briefs of 100 pages. And the tribunal came back to us and said, no, they wanted post-hearing briefs of 400 pages, which was great for the bottom line, but not good for the efficiency of the proceeding. In other examples, I think that there are more recent efforts to make cases go more quickly. But for instance, in one recent ICTIG proceeding, we had difficulty finding someone who would take on an appointment in a contract-based case
where the provision called for the entire arbitration to be concluded in 90 business days. What observations do you have about efficiency, managing the pleading schedule, and getting cases done in an efficient manner while still focusing on the issues that are relevant to the moment?
You said something about due process at the beginning. Correct. And that sort of descended into efficiency, but it's efficiency versus due process. Due process obviously should win out all the time. I won't even ask you who suggested a 400-page post-hearing brief. It must have been quite a complicated case. The deadlines are really difficult, frankly. I once had a fast-track arbitration that I designed, an LCIA fast-track arbitration. That was the first time I tried it, and the last time I tried it. And we said, you will issue your decision by such and such, and it happened to include the August holidays. And I certainly learned from the arbitrators later that, this was, if you hadn't put in such pressure, it would have been better. I think I have been asked from time to time, are you available for an arbitration which is set up in this way, and then you've got to do it within 90 days, so on and so forth. Well, I was otherwise, time-wise, unavailable, but part of the reason I was unavailable, I couldn't possibly, within that period of time, spend the time necessary to do everything that was required in other cases and hearings. I think people, sometimes there's setting a price issue that has to be decided by a certain time. And I was asked to get into those once, and it was over Christmas holidays. And so that didn't happen. Actually, I think Hudson wound up doing it. But they spent all the Christmas, New Year's holidays doing it. So they got a very good fee negotiated for it. It's really, it can be a trap. It sounds so significant, so useful, unless there's a real emergency need, as I say, to set a price or do something else that can't wait. It's potentially a trap, and you automatically eliminate from consideration a whole bunch of people you might like to have consider sitting in the case. So efficiency in general, of course, we're efficiency, but particularly if you're dealing with states and due process issues arise. I think anyone is reluctant to sort of say, no, but we won't hear it. If they've got anything like a legitimate request for more time to do something, or an additional submission, which the other side will have an opportunity to respond to, you'd rather be sure you got all the facts, and nobody's going to say later that you arbitrarily cut us off. Nobody wants to face that. We got enough problems without that. Oh.
It's 7:39. I want to abuse Judge Brower's generosity in coming here. Thank you very much for taking the time to talk to us. I know that your schedule is very busy, so we really appreciate it. You offered us very interesting remarks that really span so many different issues, historical, legal, policy-oriented, really a lot of fruitful thoughts for all of us. Thank you very much. And thank you also to the American Society of International Law for hosting us here today. This is a wonderful organization that I always feel very welcome. And if you're not a member of the society, please join us. We organize a lot of very interesting events. It's also joined the interest group on international courts and tribunals. Of course, many events throughout the year, and the main one, the annual meeting. There's a reception following just in the other room, but please join me to thank again Judge Brower for this most.